Hi, everyone. Welcome to episode 40 of the Immigration Lawyers Podcast. I'm going to have a fun interview, a special one with attorney Peter Afrasiabi, who's actually an intellectual property attorney, but does a lot of pro bono work in the immigration appeals practice, and also has written several books on the topic. It's really important to read. I'm going to have a good time talking with him about all this stuff. Just a little technical note. On the previous episode, when I uploaded it to iTunes, for some reason only half the podcast came through. And it took me a couple days to notice that only half the podcast was there. So I deleted that and reposted the entire podcast. So feel free to listen to the rest of that. So without further ado, let's get it started. Welcome to the Immigration Lawyers Podcast. I am the host, attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. All right, everyone, I have a really good episode today. I'm going to speak with Peter Afrasiabi. Peter is a partner at One LLP, a copyright, trademark, patent, and entertainment law firm. He's also adjunct professor at UCI. He's also very interested, does a lot of work in the immigration field, and that's why I want to talk with him today, especially about a particular book he wrote called Show Trials, How Property Gets More Legal Protection Than People in Our Failed Immigration System. Peter, thank you so much for coming.
My pleasure. Thank you for having me.
So why don't you fill us in how you got involved in intellectual property and how you are also doing immigration stuff?
You bet. Your guests are probably scratching their head why on an immigration podcast they're hearing from a copyright lawyer. But here's the background, because it's a very, very interesting intersection of both fields. And believe it or not, there actually is a valid intersection, and there's a lot that each system can really learn from the other, particularly the immigration court system from our federal court system. But my interest in intellectual property started in law school. It's just my passion was sort of competition principles, and I loved copyright and trademark, and so that was just sort of my interest. And then after law school, I was clerking, and I was very interested in sort of the civil rights cases and whatnot. And in the Ninth Circuit, when I clerked on the Ninth Circuit, I saw the immigration appeals coming out of the immigration court system, because the only appeal out of the immigration court system for political asylum cases or suspension of deportation, then what is now cancellation of removal, was to go to the Ninth Circuit. And I just saw this crazy set of fact patterns coming out of immigration courts, and really kind of crazy lawless-looking decisions from the immigration courts, doing things that seemed really weird and unlike what I had witnessed as a district court law clerk and what I was witnessing as a law clerk looking at appeals coming out of our district courts. And so I decided that, I saw enough troubling cases with terrible outcomes that I decided to sort of get more involved and do pro bono work in that space when I came out of law school. And so I started taking political asylum appeals in the Ninth Circuit pro bono. I started doing pro bono immigration trial work in the immigration courts in Los Angeles for political asylum seekers. And then I started teaching a clinic at the time at Chapman Law School doing immigration appeals in the Ninth Circuit with my students. And that then went on for many, many years as I litigated many cases in the immigration courts and in the Ninth Circuit on a pro bono basis. And that probably takes, took up and takes up 20-25% of my time. And the rest of my time I was just practicing law, earning a living, doing my patent, copyright, trademark cases. And as the years wore on, I did my clinic, and then I moved the clinic over to the UC Irvine School of Law when they asked me to take the clinic there, as they were, and are very, very involved in clinical work and immigrants' rights projects and whatnot. And at the time, I started developing a thesis over time in my mind, really, about this staggering disconnect between the two systems, because I kept in my arguments in my immigration appeals, I kept drawing on what was going on in my regular cases in the court system, arguing that, we have these processes and systems in place that protect property rights. And here I am in comparable situations with human beings facing a loss of life or liberty, and I don't have comparable protections, and this is crazy. And I was trying to make analogous arguments and try to get the court to sort of import doctrines from our civil system over. And that sort of gave rise to the thesis for the book, which was that there is this staggering disconnect between the two systems, and that in stark terms, property is receiving more legal protection than people. And it crystallized in my mind, really, where I had two very, very similar factual circumstances occur at the same time, one in one of my immigration appeals that I was taking and one in one of my real cases. And that's a situation where, I had a copyright case and I didn't show up for the hearing and I just missed the deadline and I was upset and embarrassed, obviously. But I was never freaked out in a deep sense because mistakes happen and there's a whole bunch of legal rules in place in our court systems that if we don't show up, the court will give you a second chance. You may get yelled at. You may get sanctioned. But in essence, we abhor forfeitures of people's rights, and we want things adjudicated on the merits. And there's a massive amount of rules and doctrines in place to make sure that lawyer mistakes don't just decimate a case and destroy one's property rights. And that was in a copyright case of mine. In the exact same time that I made that mistake, and I wasn't particularly stressed out because I knew I would go and apologize and my case would get resuscitated. I was dealing with an appeal for a political asylum refugee from China who had been the victim of a translation error in terms of the time he needed to be at court. And so he showed up at court at the wrong time and he'd been just ordered deported, with his absence, in absentia. And he then went and, gave affidavits and showed that there was an error. He arrived at the wrong time because the translator gave him the wrong time. And the response of the immigration court was to say, well, it's too bad you don't get a second bite of the apple. You're ordered deported. Your case will never get adjudicated, and, that's life. Move on. Which is incredibly harsh, obviously, for someone who could be killed if returned to a foreign country. And it's the antithesis of what goes on in our system that deals with, if someone stole your bike, you get a hearing, and if you don't make it, you can, you don't lose your bike forever. And my client didn't lose his copyrights forever. And so that sort of gave birth to my idea to really start exploring in more detail the myriad aspects of the two legal systems in terms of how different they are and how unfair they are and why we have this massive disconnect between our desire to protect rights in our civil court system and the absence of comparable protections in the immigration court.
That's amazing. That's the most startling thing when I read the book. I don't do as much removal proceedings anymore, but it is shocking just the lack of liberty, even for people that may have a chance of success, where they go to court and just completely decimate or miss a small thing and then have huge repercussions. One of the most interesting things was the IRIRA, the change in the immigration laws that occurred in the 90s, and how they stopped sort of judicial review by the Article 3 courts from immigration decisions. Could you talk about that and what effect that's had?
Sure. In 1996, when IRIRA and EDPA were passed, the Anti-Terrorism Effective Death Penalty Act, that radically changed the immigration litigation system from a rights perspective because IRIRA started curtailing federal court, Article 3 court review of hardship determinations. And so the result was that, from that point forward in time, if someone showed up in immigration court, they put on their case before the, what's called an immigration judge. And the immigration judge decided, deportation won't visit a great hardship on you. That assessment of whether there's real hardship or not is unreviewable by a neutral federal court. And so, in effect, the executive-controlled court system is the final decision maker on that. And that has staggering repercussions when one peels back, and looks behind, the curtains, so to speak, in terms of, who are the judges that are deciding things? Because immigration judges are not like our Article 3 judges in terms of, experience levels and background levels. And, we expect our Article 3 courts to, be fair arbiters of cases, but the people who get on the courts are vetted through a complex process and a system, and there's always appeal rights from a trial court decision. But immigration judges are really just appointees. They're political appointees who get hired, and they don't need much experience, even much immigration experience, it turns out. And the idea that they're in a politicized system, their decisions become final and unreviewable by a neutral court is extremely alarming and has led to, massive deportations of people who may, in a pre-1996 regime, have been able to have their case heard by an Article 3 court. And Article 3 court would have concluded, that's wrong, it's improper, and those people shouldn't be deported. And those legal changes that took root in the mid-90s sort of started creating a crisis in the system in terms of unreviewable decisions and deportations of people who may or may not be worthy of being exiled from the country. And this is sort of a perfect example of one of the disconnects, because if we are going to remove someone from the country and say that they're not entitled to their liberty right to remain here and the life that has taken root from them here, we should do so only if we've exercised the most meticulous care, according to the U.S. Supreme Court in old immigration cases. And we would hope that, I think, systemically as a system, that if the people are bounced out of the country, it's because they deserve to be bounced out, and every fair look has been taken at their case, and they've had a really fair process. And in a fair process, some will get deported, some won't. And, when you then pivot from that to sort of what goes on in my cases involving patent rights, trademark rights, copyrights, contract rights, all the stuff that we all think about every day, even sort of small claims cases, if your neighbor, cuts down a tree and it falls on your fence. I mean, all of these types of cases involving property rights, there's always a right to appeal. And if you think about our patent system in particular, my patent cases, we have a specialized court that hears appeals of all the patent decisions. And so we as a system have decided that these property rights and patents are so important, we must have an appellate court that's highly specialized and focused on patent rights and property rights and patents and intellectual property to make sure that mistakes are not made. And so there we've, embedded this critical concept of appellate review to protect property rights. And at the same time, that specialized court came about in the early 1980s. Less than a generation later, in the mid-90s, we started dismantling even what limited appellate review rights existed in the federal courts of immigration cases dealing with life and liberty rights. And there's just sort of this startling disconnect between the two.
Now, just to play devil's advocates, with the sheer numbers of immigrants going through the immigration court system, if appellate review was allowed, or maybe pre-1996, was it something that clogged up the system? Do you know statistics on this? Like if it was just too much to handle in the district court? Is that possibly a reason? Although, just because it clogs up the system doesn't mean you could take away someone's rights and ability to live in liberty and freely. But would the sheer number of immigrants in immigration courts create a problem within the whole system?
I don't think it ever did create a problem, and that wasn't one of the articulated rationales for passing ARERA and stripping the courts of review rights. So I don't think that, and I don't have data, but I don't think, in light of that not being part of the avowed reason of doing it, that it was aimed at helping the court system. The reality is that the court system has been massively taxed in the 2000s, at least. It got very, very heated by sort of 2005-06 in terms of the number of immigration appeals of cases. But that wasn't a function of the ability to have appellate review rights. It's just a function of the number of cases that are out there. This certainly stripped, for those people seeking suspension of deportation or cancellation of removal now based on hardship, that hardship determination was yanked out of the equation, and those people no longer get to appeal. But all the political asylum cases, they still have appellate right review in the federal courts, and the federal courts have managed and handled those cases admirably, even though they make up a massive portion of the court's docket. So I don't think it would be, even if that was the problem, I don't think that's the appropriate response, obviously, in terms of how one deals with it. But that wasn't actually sort of the underlying root cause that led to ARERA and EDPA that sort of started curtailing appellate review rights and habeas rights for district court review of cases. Those statutes really were born out of the broader political climate dealing with immigration, and after the Oklahoma City bombing, there was suddenly mass paranoia about foreign terrorism, and that was sort of one of the very avowed reasons for curtailing certain court review rights in immigration cases. And so the rationale stemmed from a different place, and so I just don't think that's it.
I agree. Now, the next thing is, how do we fix this? And, in one sense, on the political side, it's very difficult because immigration is so controversial, and Congress is all over the place with it. With Attorney General Jeff Sessions in it, it doesn't look positive in any way. But one thing I noticed in your book that you mentioned a lot is something that potentially we as attorneys in our community can control a little bit is the quality of lawyering and education that happens. There was a case you had where a young man had two attorneys that completely destroyed the case. It was an approvable case. If you could briefly talk about that, and then we discuss how we could kind of police this internally and some methods we'll discuss to do that potentially.
Yeah, I think part of the problem is that you have an overworked bar. When you're talking about the immigration bar, there's no statutory right to fees. There's no right to counsel that's given to people who are in, for example, political asylum, deportation, removal proceedings. And so you have a population who doesn't have massive resources. The Contra cases, sort of my intellectual property clients, for example, Disney or whoever these companies are, they all have money to protect their rights. So you've got a bar that is underfunded from their client base, and so overworked, and so mistakes happen. And so when you look at the data from the Ninth Circuit in terms of lawyers who get disbarred by the court and subject to disciplinary proceedings, the immigration bar by a factor of 10 is punished and sanctioned more than non-immigration lawyers, and part of it is because of those economic realities, that there isn't sort of a market mechanism that exists to enable people to earn a proper living in that area from a client base that doesn't have the resources, even though there's massive liberty questions at stake. And so, you're right. Given the current climate, there's no possibility of fixing that market deficiency by legislation. Good legislation would be, for example, giving a right to attorney's fees or appointing counsel even. And those things are literally never going to happen, obviously, now. They didn't even happen under President Obama, obviously. So I think one has to look to more creative mechanisms that draw upon the private bar, both civil lawyers like myself, but also listeners of yours, for example, who are transactional immigration lawyers doing this sort of corporate transactional immigration work, for visa work for companies and for highly skilled foreigners and whatnot. The bar of lawyers outside political asylum type lawyers needs to become a part of the solution in a massive way, which one of the bright spots in the last 6 months, I think, has been that despite the unbelievable litigation that's unfolded from these ban orders from President Trump, you've seen a massive response from the private bar. It's one of the things that I think has been fantastic to witness in terms of the lawyers showing up at airports. The ACLU and the other public interest organizations are involved in massive amounts of litigation to try to patrol and help this area of the law. But the reality is more help is needed. More help is needed everywhere, and there just simply aren't enough resources or lawyers in the public interest organizations to litigate all the cases that need help. And so I think private mechanisms need to be created by people like you, me, your listeners, to try to really start working towards systemic solutions that can sort of make sure that even though we don't have a top-down set of rights, we can at least, if we get enough lawyers involved in cases, we can make sure that each individual case gets litigated within the system that exists as fairly as possible, with as much success as possible.
I agree. The one difficulty is the way the court system works, where you're on the hook for a case for like 4 or 5 years in the future, which is kind of hard to plan out. And that's just the lack of immigration judges and space for hearings. The other is the complications and how complicated it is to go to immigration court, all the nuances where experience really does matter. For example, a lot of civil attorneys might want to come in, but learning how the system works, what adjustment of status is, what does out of status mean, what does an unlawful presence mean, all this stuff takes a lot of time and research and education. Southern California AILA has a bond hearing, for example, how to do a bond hearing this Thursday, and it teaches that stuff. But maybe having more courses like this for general attorneys to learn and to study the nuances would be very beneficial. I guess education is the title of that method of helping things. But how did you had experience around, you had clinics, but it did take a while to wrap your head around the whole immigration system and how to deal with these. How long did you feel it took you to be confident and going to a hearing and knowing what was going on?
You're absolutely right. It took a while, and it wasn't easy. I was fortunate that there are resources that can help. So I was a young lawyer, and I took immigration trial court cases from public counsel would assign me, and the lawyers at public counsel would help and give tutorials and point me to directions. And it was difficult, and it took several years to really feel comfortable being in this system that's very different for civil lawyers from our normal court system in terms of what we're used to and the procedure and how things work, and it's stressful and confusing. There are resources, but there are not enough resources. And so I think your question's a really good one in terms of education and that program you referenced. Part of a solution, I think, is getting the immigration bar as a whole to have more interaction with the non-immigration bars. I think the bars get siloed often, and they're too insular, and the intellectual property people only talk to the intellectual property people, the immigration people only talk to the immigration people. But this is an area where the civil bar needs to be invited in and be given programs that get put on by experts like you and the lawyers who listen to your program and who are immigration experts, who can put on detailed programs that you do a 2 or 3 day seminar, for example, and civil lawyers can attend it. Maybe it's online, maybe it's in person, and get enough of an overview that then they can feel comfortable going into court and litigating these cases and trying these cases. I mean, it is difficult, but it's not overwhelming and insurmountable. We're not asking people, obviously, to go into court in the Soviet Union or something like that and fight a case under some crazy new regime. I mean, it's still America, and it's a system that people can learn and learn quickly, and the language can be learned and learned quickly. But I do think that it requires more outreach and more interdisciplinary work between the bar organizations in order to get civil lawyers trained up to ready to go in and fight. Because civil lawyers are, by and large, love to do pro bono work, especially when you're talking about mid-sized and large firms. The firms have a commitment to pro bono work. They want their lawyers to go out and do cases. And these structures that get put in place can allow lawyers to go and take immigration cases and try them. And I'll tell you, one of the things that I found when I started my career and I was at a one of the big international law firms was that the immigration trials in many ways were perfect for me because I could take a case and it was a discrete amount of work, which is very different to normal civil litigation that can get sprawling and out of control, and it can consume your life. An immigration case, if you're putting on a political asylum case, you're going to have a couple witnesses. The government may not have any witnesses. Maybe you can find an expert, maybe you can't, but it's the type of case that unfolds with a day and a half of testimony at tops. You put on a case and it's over and done with. And so the fact that it's a discrete time commitment makes it very easy to sell to the private bar to go in and do the cases. So what's needed more is the education and then a mechanism to make sure that all of the immigrants showing up in immigration court, when they learn about the pro se clinics and the pro bono clinics that are out there with lawyers willing to take cases, and they try to connect to the immigration bar of Los Angeles, for example, in order to find a lawyer. We need more lawyers who are on the list so that cases can just be every single person who calls can always get a lawyer to represent them. And I think without the educational outreach and the programs, you're going to be forever limited in terms of the number of lawyers we can get into the system, the number of lawyers like me who are outsiders who you can get into that system.
That's a great point. So, I could talk with SoCal ALA, for example, the pro bono section to set up things with maybe LA County Bar Association, connect those with, Beverly Hills Bar Association, Mexican American Bar Association, ethnic and locational bar associations, have them come and have them on the list. And also then hook them up with the law school clinics. I've had difficulties connecting with the law school clinics and creating like a centralized location I could send out cases to everywhere. But if these systems are able to if we could coordinate these different groups together, the resources are there. I think it's just the logistics thing of getting the client to the people and the lawyers and educating the lawyers at the same time. But it should be something that's doable. Just working together on this. That's a great idea.
I think you're right. I think it's a logistics thing. And I think one of the things that your listeners could do, not all law schools have clinics. We are fortunate here, for example, where I am in Southern California, that most of the law schools have clinics doing this. But not all law schools do in California, certainly not all law schools around the country. And so one of the things that could be done is immigration lawyers could go to their local law school and say, hey, let's start a clinic and let's get going. And I'll take cases, I'll take students, and I'll supervise and mentor the students. The students will learn how to do the work that lawyers do, and we can get a clinic going to help people. Those are win-win for the law schools, because the law schools, there's such a heavy focus in this day and age on clinical training and really preparing students. And what better vehicle than to have some witnesses that you put on a witness stand, maybe some cross-examinations, openings and closings in a mini immigration trial. It's great for the students in the law schools, and it becomes a way for you, the practitioner, to run a clinic, which is great for you and your resume in terms of getting your own private business. But also then you're helping people through the clinic on a pro bono basis, and cases are getting taken and sold. So maybe your listeners can reach out to their local law school and try to start clinics.
That's a great idea. And this is national. We have listeners from everywhere. LA is pretty saturated. Luckily, we have a lot of clinics doing a lot of work from your school, Loyola, and various other schools. But that's really needs to be a program that's national, because there's a lot of underserved areas where they have a lot of immigrants facing these kind of situations. Immigrants that have good cases, actually, but they have no way to defend themselves. So I'm glad they were able to talk, and hopefully our listeners could take part in that. We're reaching a 30-minute mark, so I want to see, is there anything else in particular you wanted to talk about before we leave?
No, I would, if your listeners are interested, I'd certainly encourage them to please, read my book. You can, if you're an Amazon Prime member, you can get it for free on Amazon Prime. It's called Show Trials. And if you ever have any questions, by all means, email me. I love to talk to people about the stories in the book and the situation. It's something I write on extensively. And, I hope this has been informative, educational, and interesting to your listeners.
It has. What is your email? And do you have like a Twitter or Facebook or something else where people could connect with you?
I don't have Twitter or Facebook, but, the book is called Show Trials. My name's Peter Afrasiabi, so I'll spell my email, PAFRAS like Sam, IAB like boy, I, at onellp.com, ONELLP.com. I love getting emails from folks who have read the book and have questions or comments, whether you agree or disagree with the book. I certainly would love it and welcome it.
Great. And one more thing, you have a great book coming out that I'm looking forward to, because my knowledge of the area is limited. But could you do a short introduction of your new book coming out, and we'll discuss that one next month?
You bet. So the book Show Trials that we've talked about today is sort of a contemporary look at the immigration system. And the book that I have finished, that's coming out June 15th, is called Burning Bridges. And that book takes us back really to the inception of the modern immigration system. And it's a look at the longest and most bitter deportation battle in American history. It was a series of 4 cases that lasted for 20 years as the U.S. government tried to frame a labor leader in San Francisco named Harry Bridges. They tried to frame him as a member of the Communist Party. And under the immigration laws of the time, if one was a member of the Communist Party, they could be deported for being a member of a party that sought the overthrow of the American government. And so I have gone and got his Harry Bridges case went to the U.S. Supreme Court twice. It was a 20-year saga. He was imprisoned for a stint for speaking out against the Korean War, and I went and did some FBI FOIA demands and got some remarkable documents from J. Edgar Hoover's vault. I went through all the original trial transcripts at the National Archives, and it's really a stunning story of prosecutorial abuse and aggression of really larger than life defense lawyers, private civil rights lawyers, pro bono lawyers, and defense lawyers fighting to save this man's life from both prison and a wrong deportation, and suffering huge consequences for their advocacy efforts. And it's a story really of good judges and terrible judges who had their thumbs on the scale of justice and did really terrible things in terms of subverting due process. And ultimately, what's so interesting about it is it's a story of a battle between the executive that wanted to use this immigration system as a means to persecute and stamp out dissenting viewpoints and dissenting speech and thought, and the judicial branch that had to stand against the executive branch. And so you have this story of the judicial branch prostrating itself at times to the executive and allowing this injustice. But ultimately, the case is reaching the Supreme Court, and ultimately, with certain judges who stood firm against the executive and insisted that, basic American principles of due process have to stand at the end of the day. And in the middle of all that, you had one lone man who was fighting for 20 years to sort of preserve his American life. So it was sort of an incredible set of trial records to look through and read. It was sort of magical to hold these ancient, trial transcripts and lawyer files. And so that book is called Burning Bridges, America's 20-year crusade to deport labor leader Harry Bridges. The website's burningbridgesbook.com, and it comes out June 15th.
Thank you so much. I look forward to reading that book. Peter, thanks so much for coming and speaking with us today.
You bet. My pleasure.
Bye, everyone.